The broadcast is now starting. All attendees are in listen-only mode.
So good morning, or sorry, good afternoon, everybody, and welcome to our webinar this afternoon, which is again, it's part two, I suppose, in a very successful series we've been running on GDPR, and it's in this episode we're going to talk about lawful processing, the do's and the don'ts. Okay, so I see people are logging in, so I'll just give people another couple of minutes just to log in, and then we will get started. So now. Could I just ask somebody in the question box just to confirm that you can hear me okay? And that would be great. Okay, thank you for saying yes. That's great. Um, okay. All right. Thank you all for confirming that you can hear me. Okay, so we still have a few people coming on there. All right. Okay. Well, I'm going to start, and as I say, okay, just a few more coming on. Okay. So, well, welcome to the webinar, and what you're looking at there is you are seeing the title for our webinar today, and we're joined again by Gary Hibberd, who did a really excellent presentation the last time. So this webinar, like the last webinar, is co-presented by our self-storage and one of our good partners, RapidFire tools. So I'm just going to take a couple of minutes out for those of you who may not be familiar with StorageCraft, just to tell you a little bit about who we are and what we do. So I'm not going to read everything that's on the screen. You can see it there. We're a well-established, long-established company, founded around sort of the area of disaster recovery and business continuity. And we've been really successful in that area. In recent times, in the past 2 years, we have enjoyed a massive injection of funds, and in order to kind of move the business forward. And we also made two very successful acquisitions. So in the course of our history, we have some excellent partners, excellent relationships. This is our sort of our ecosystem, if you like, because companies that use our products, and some of them are OEM partners as well. We have a lot of customers across a whole range of verticals, and some names there that you'll recognise. People like Kawasaki and Sonic. These are the enterprise customers, but it comes right down to sort of local small customers, and again across a whole range of verticals. Okay, in terms of who we are and what we do, this is our mission, and this is where we position ourselves. And we say, with StorageCraft, your data, it's always safe, it's always accessible, and it's always optimized. So there are three promises, and in order to deliver on those, we have a range of products. Our core, our legacy product, I suppose, is StorageCraft, is the Shadow Protect range, which a lot of you will be familiar with. This is our data protection piece, which allows you as service providers to protect your customers' data, and to offer services like disaster recovery as a service or backup as a service. And we've been doing that very successful. As I say, the newer sort of division to the company is around the storage piece. And that's how we deliver that product, that promise to you of making your data always accessible. And this is our range of one blocks storage, scale-out storage solutions. And we're very excited about this. We see great potential in this, and this is, as I say, this is something that you're going to be hearing a lot more from us in the coming sort of weeks, months, and years. Okay, so that's kind of the 20-second introduction to StorageCraft. And I'm going to now hand over to Tara Newman from RapidFire Tools, who's going to tell you a little bit about RapidFire Tools and what they do. So bear with me while I hand over to Tara. Okay.
Good afternoon, everyone. Give me 1 second. All right, I hope by now everyone can see my screen. So thank you, everyone, for attending today's webinar on GDPR. My name is Tara Newman, and I'm the Director of International Sales and Marketing with RapidFire Tools. Some of you may know, and others may not, that RapidFire Tools got its start as an MSP over 10 years ago. We are the market leader in IT and compliance assessment software. We sell only to the MSP and VAR communities and never directly to your end users. We take our job of making you successful quite seriously. So what does RapidFire Tools do? We specialize in 3 core things. 1, agentless and non-invasive IT assessments made fast and easy. 2, internal cybersecurity, meaning the alerting of risky human behavior that takes place behind the firewall, behind an antivirus. And 3, comprehensive compliance reporting and documentation. Those 3 core competencies fall into 3 product groups. Network Detective, the #1 IT assessment tool for MSPs, Detector SDS for internal threat detection, and the soon-to-be released Audit Guru, which will take what we do today for compliance reporting and upgrade it to an ongoing solution that will help you prove best efforts towards compliance. The first regulation we are tackling with this tool is the General Data Protection Regulation, or GDPR. That tool is planned to be released this February. GDPR, as you know, or you probably wouldn't be on this webinar, is fast approaching. The compliance standard was introduced in 2016 and was designed to create a standard methodology for protecting and keeping personal information private. We have designed Audit Guru as an assessment, reporting, and documentation tool that will allow you to help your clients show ongoing best effort towards this compliance standard. Essentially, it's going to become your compliance officer in a box. On the screen now, you can see a list of reports that you will be able to generate with Audit Guru for GDPR. We have been working with policy experts, compliance lawyers, and technical specialists to become GDPR experts ourselves and put that expertise into our product, so you don't have to incur that heavy overhead cost. The solution is also going to automatically scan your client's environment looking for information relative to GDPR compliance. It's going to create all the documentation on the screen and take you step by step through the process, uncovering compliance-based risks and issues, and tracking the remediation of those issues. And if you're using popular PSAs such as ConnectWise or Autotask, you'll be able to take any issue we find and automatically generate a ticket in your PSA, so you can get your clients moving quickly towards compliance. If you're interested in finding out more about our product and our partner program, please go to rapidfiretools.com/GDPR and sign up today. Those that do will get a special introductory offer upon release. But first, and most importantly, we have on the line today Gary Hibberd. Gary has 32 years of experience in the IT industry and is the Managing Director of Agency, an international cybersecurity consultancy. Gary is an expert in GDPR and has become a renowned, experienced practitioner on the subject. I know Janet and I are really excited to hear what he has to say, and we're really glad that you're joining us this afternoon. Gary is going to talk to us today about the data do's and don'ts of GDPR. So Gary, let me make you the presenter. And yeah.
Thank you, Jan. Thank you very much, Tara. Thank you very much. And I will just make sure I bring up the correct screen here. And good afternoon, everybody. And I hope you can see what I'm looking at right now, which is it should be the presentation. Apologies if you can't. Just one second. So hopefully you can see a presentation in front of me, in front of you right now, which is the agency logo. And thank you very much for that very kind introduction. The purpose of this presentation, of course, is to talk about the do's and don'ts for MSPs regarding the General Data Protection Regulation. We're going to focus on one particular aspect of this, though, so I hope this is of interest, which is it's all around lawful processing, and I'm going to focus on this because this is an area which we are asked quite a lot within agency, agency are a cyber security, information security, data protection business, and we are really about information governance. We're not lawyers. We all have IT backgrounds. We are not service providers in the sense that you would describe, but we do provide a service around security, around ISO 27001, the information security standards, through to Cyber Essentials, and of course many other different security frameworks. Now, this is meant to be a presentation which gives you some real value, and I recognise, as I'm going to be talking through this, you may want to take some notes. So what I have done is I've provided as much information on screen as I possibly can for you. So I will start out by saying that I am sorry that the screens may look a little bit busy as we progress. You'll be pleased to know I'm not going to go through each and every point on the pages as we go and we progress. I will go through a number of bullet points, but hopefully I'll give some context to each of the points that's on the screen before you. But the idea is that at the end of this presentation, that you have something that you can take away with you, that you'll be able to refer to within your own businesses, and you'll be able to talk to your own teams about. So, without further ado, what are we going to cover? Well, our agenda is essentially made up of three things. We're going to talk about what you need to know in terms of GDPR. So recognizing, I'm sure most of you out there, if not all of you, know what it is. I'm sure you've all read the regulation, or maybe not. So I'm going to just give you some of the headlines that I think is important. We are going to talk about lawful processing, and I'll try and explain where that fits into the whole context of GDPR. And of course, the final part is just almost some thoughts from me, is just two or three areas where we are seeing people trip up, and we're seeing MSPs starting to, or perhaps not really understanding what their role is within GDPR and what their responsibilities are, which is kind of key. So GDPR. What do you need to know? Well, what you need to know is that this is, as Tara already mentioned, this is a regulation that has been we've been long waiting for. It actually started its life back in 2012, and essentially the ICO, the Information Commissioner Elizabeth Denham herself stated that this is one of the biggest changes in data protection law and regulation for a generation, in fact 20 years. So 1998, of course, is the last time when we had any real significant changes in our data protection laws. It's the spirit of the law. This is about making sure that organizations understand what they should be doing around protection of data. And as Elizabeth stated there, and I think these quotes are really helpful, I think, and can be used in your own presentations, just to remind people and the business that having customers' trust within your organization is an important factor. And I think as MSPs, getting people to trust you by having the security standards in place, like 27001 and other standards, is really important. But in terms of GDPR, what it is in a nutshell, well, within agency, we have a plaque on our wall, and it's something that we believe very strongly, and that is that GDPR simply stands for giving data proper respect. It really is that simple. If people are coming to me and asking me questions and saying, but if we can do this and we can do this, and it almost feels like they're trying to wriggle the way through GDPR, my response to them is, well, you're not really entering into the spirit of the law. What it is trying to do is ensure that people's data, personal data, is given proper respect, and that's what it's about. So in terms of the headlines, what do you really need to know if you are coming to this fresh? Well, there's a couple of things which are important, which I think we should all be trying to remember, and that is that it comes into force on the 25th of May 2018. Although having said that, of course, this isn't just that date that we need to be thinking about. It goes beyond the 25th of May. It is about every organization, irrespective of your size or your sector or your complexity. Essentially, if you hold and you manage data, personal data, then you need to think about this. You as MSPs should be thinking about data breaches and about management of those, because the new rules, or some of the new rules, include this requirement that within 72 hours of a breach occurring, or you becoming aware of a breach, that you need to inform the ICO and possibly the data subjects themselves, which I'll come on to a little later. And of course, as I'm sure you're aware, the roles of data controller and processors are changing, and there are indeed 6 principles replacing the current 8. So they're the headlines. Now, you've probably noticed that I managed to get to the end of those headlines without mentioning any fines, and that's because I'm going to purposely avoid the point of fines, because far too many consultants, far too many people are selling fear, uncertainty and doubt. Yes, there are fines. Yes, there are bad things that can happen in the event of something going wrong. However, what GDPR is about building an opportunity for MSPs and for other businesses to be able to demonstrate that they are treating data with respect. If you're interested in knowing what the fines are, I will simply point you to countless other presentations that are out there, or articles, or LinkedIn, or just simply go and read Article 83 of the GDPR and get the full picture of what it means about, what it says about fines and such like. So that's all I'm going to say on that particular topic. So what is GDPR all about? What is it trying to do? Well, fundamentally and principally, it is trying to set in place a number of actions and a number of rules around the protection of personal data. And personal data, the definition of this is here before you. Again, I've taken the exact wording from the regulation. This is Article 4.1. This is the very first definition underneath the in the chapter or the article that describes definitions, and it's an important one. So it's right there at the forefront. Personal data means any information relating to an identified or identifiable natural person through any of those means that are before you there. So it pretty much covers any way that you are going to identify a living or natural person as it's described within the GDPR. So that's the first definition I think that is important for us. As MSPs, there are 2 other definitions which I think are quite important for us to be aware of. And the first of which is the data controller. The data controller means essentially the natural or legal person which alone or jointly with others determines the purposes and means of the processing of personal data. So many of your clients will be defined as data controllers. They're the ones who are setting the rules. They are the ones that are telling you how they expect that data to be managed. Now, that's great, and that is probably not news to anybody who is on this call, because that's the way it's been for a very long time. But just hold that thought for 1 second, because I'm just going to show you the definition now of the data processor. The data processor means a natural or legal person or other body which processes the personal data on behalf of the controller. Now that, as you can see, is a far shorter description, and that's fine. But what isn't shown on screen, and what you do need to understand, is that the data processor and the data controller's obligations are almost identical now. So it's as important for you as the data processor to be able to articulate and describe your security to your controller and your expectations of the controller. So, for instance, we are now working with organizations, MSPs and other providers of technical services to write contracts in such a way that they place obligations on the controller, that they are stating to the controller that any data that they have, that they are processing has been obtained in a lawful, open and transparent manner. So it's those kinds of things that you need to think about. So again, when we come to the end of this, you'll hear me talk about this reviewing of contracts, which is so vitally important. So they're the data controller. and there you are as a data processor. So what we need to think about now is how all of this hangs together. What really is at the crux of the GDPR? And of course, it's the principles. We all have principles, I'm sure, and these principles set out almost our objectives and our strategy and our vision and our rules for life. That is the whole point of GDPR. These are principles that we should all follow when it comes to treating data with proper respect. And if you have not read GDPR and you're wanting a quick cheat sheet to understand, well, I only want to know the key principles, what do I really need to know? Well, these are the principles that you need to be aware of. And these are laid out in Article 5, in actual fact, Article 5 to 11, that you should actually go and read. So if you're going to read the 261 pages, or if you don't want to read the 261 pages, these are the sections you need to look at. And these are the 6 that are now replaced the current Data Protection Act's 8 that is in place. And they're not that different in actual fact. It's just a consolidation and an improvement, if you like, an enhanced aspects of each of these. I'm not going to go through each and every single one of them because today's webinar is really focused on the first principle. It's all about this idea of lawful processing. But when I have organizations come to me saying, Gary, GDPR is too difficult, do we really have to do this? Does it really matter, or does it really affect me? I ask them to read Article 5 and then say to me and ask them to tell me why they think it is difficult or wrong for them to hold data in an accurate way, or that they are only going to use that data for the purpose that they have actually stated they're going to hold that data for. If they're a type of organization that it can be trusted, they will hold it with integrity and confidentiality. Those seem very, very sensible principles for any organization, and I would be surprised if anybody on this webinar would argue that they are bad things to have in place. Of course, there is a 7th principle which we should be aware of, and this is something that is very important, and it's known as the principle of accountability. And this simply means that your organization will be held accountable. And when I say your organization, if there is a breach, it will depend upon how that breach has occurred or where it has occurred to where any penalties will be or faults will be held liable. Now, this accountability for me is not about the bad side of things, it's about the evidencing. So when we talk about putting GDPR in place, and again, Tara made mention of the compliance in a box, which I thought was a great phrase. I think the idea here is that you must be able to demonstrate that you have all the things in place, that you've taken reasonable care and attention on people's data. And that is, I think, is absolutely paramount. So the remainder of this webinar is all about this very first principle. What is lawful? When we talk about lawful, the way that you can, is it legal for you to hold this data? Do you have a right to hold this information? That's the key question that is being asked under that very first principle. And all too often when we talk about that principle, people fixate on the very first aspect of a legal basis upon which you can process data. There are indeed 6 reasons why you might want to process data, the very first of which states that the data subject has given their consent to the processing of his or her personal data for one or more specific purposes. And as it states here, if it's not clear, if it's not, then it's not consent. You have to provide very clear and very definite or be able to evidence very clear and very definite consent has been provided. And in terms of how you would obtain that and how, you know, the conditions for consent, again, I'm going to present something to you here. So you have this right here, right in front of you. Article 7 helps you in GDPR that says that the following conditions apply for consent. The controllers must be able to demonstrate that it was given, that the consent must be clear, intelligible, easily accessible, and else it's not binding. I'll leave you to read the remainder of that if you wish, but essentially what this is saying is that unless you can demonstrate that you have that the data subject, that means me, has given clear indication that they want their data to be processed, if it is under consent, that you don't have a right to hold that information. Consent usually comes into force or into play when we're talking about marketing. And I'm going to leave it at that at this point in time. I'm going to move on to some other areas. But I am going to say for anybody out there who is involved in marketing, not to worry, because under Recital 47, recitals are part of the regulation. A recital simply offer examples and guidance around how the regulation will be interpreted. For those of you who are in marketing, I'm going to offer you a glimmer of hope, and we will return to this point later. This is the entirety of Recital 47. Don't worry, I'm not going to read it to you, and you don't need to read all of it. I'm just going to highlight the final part on here, and that says that the processing of personal data for direct marketing purposes may be regarded as carried out for a legitimate interest. So we'll come on to legitimate interest in a few moments, but essentially what this is saying is that if you are asking somebody for permission to market to them, as long as you are clear about that marketing activity and what you're going to do, then in actual fact, you don't have anything to worry about, as long as you're doing that in a clear and transparent manner, and it is not written in legalese so that people can't truly understand. It needs to be relevant, and it needs to obviously be appropriate as well for the data subject. So that's all I'm going to say on conditions for consent for the moment. I am going to return to the lawful processing and come to the second reason, and probably the reason why you will process most of the data that you have access to. And the lawful basis that I'm thinking of here is that processing is necessary for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into a contract. This simply means that when somebody approaches your organization and says, I would like you to hold my data because we collected this data on behalf of our clients who's a law firm or it's an accountancy or whatever it might be, they are entering into a contract with the data subject, and when you go and obtain services from an organization, you again quite possibly are entering into a legal contract. So for you to process data, more often than not, it will be operated under this basis. And it's under the context of this that, to be perfectly honest, if I was rewriting GDPR myself, I would probably put this right at the front, right at the top. Rather than it being B, I would make this A, because this will be probably more often than not the basis upon which you are processing data. The next reason that you will be processing data is that your processing it is necessary for compliance with legal obligation to which the controller is subject. Now, this is where processing is carried out in accordance with a legal obligation to which the controller is subject, or where processing is necessary for the performance of a task carried out in the public interest, for instance, or for an official authority. Now, that simply means that, for instance, where you are holding data for taxation reasons, you can't hold on to data for time immemorial. You can't keep it for 20, 30, 40 years, and unless you can demonstrate you have a legal basis for holding that data, and there may be a legal obligation on you to do so. So tax is a good example. So the HMRC will expect certain records to be held for a certain amount of time. Your HR records, for instance, will be held for a certain amount of time as well, because of course you may, when somebody leaves the organization, they may be called to recall some of their information, their personal information. After that time, once they've reached a certain time, usually from a HR perspective, it's around about 7 years, you would then release that information. So you shouldn't be holding it unless you have a valid reason to do so. The next reason that you may want to hold information is not actually for compliance to legal obligations, but it's actually for the vital interests of the data subject or of another natural person. So in that respect, this is the processing of this personal data is regarded by law where it is necessary to protect the interest of an individual, and it says vital interest there, and that typically means something that is of life or death. So you can imagine, for instance, when people say, well, can I exercise my right to be forgotten? Well, you can, but you wouldn't want to go to the hospital and ask for them to forget about you, and even if you did, they would simply say, we can't do that, we must hold on to this information. So medical records will be held for all time because it's in your particular interest. It could be, it talks about here another natural person. Well, this is all about processing your personal data based on the vital interests of another person, only where it's in regard of some life or death situation in terms of epidemics or such like. So again, this is probably more into the world of research that the hospitals and other facilities might want to undertake. In terms of the penultimate reason why we would want to hold some information, well, processing is necessary for the performance of a task carried out in the public's interest or in the exercise of official authority vested in the controller. So again, some of this is the performance carried out in the public's interest. It could be, whilst this is an area that again touches on this idea of epidemics and holding information, big data almost, where we're holding onto information that will allow authorities to make some decisions, and this could be, for instance, on credit risk. So again, in the interest of a wider group, they may, these credit referencing agencies may need to hold on to certain types of information about individuals because it's in the public's general interest and not in yours. So again, if you're a public authority and you are managing data and they are handing that data to you as an MSP, then again, you will have to speak to those bodies and understand what their data restrictions are and their data retentions and their rules around that. The final area of lawful basis for processing really comes down to almost a catch-all, and that this is processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party, except where such interests are overridden by the interests of fundamental rights and freedoms of the data subject. Now, what that all means is simply this, that when, if I can give you an example here, this is where somebody comes to you for certain services and they've come to you for hosting, for instance, and they come to you and say, I want you to host my services and my data. If you have complementary services, if you have another part of your business which deals in VoIP or complementary services, then it is within their legitimate interests to be informed of those services that you provide. If you, however, were a multinational business and you had many different strands to your business, and I'm going to go to a different kind of sector here, but let's say, for instance, that you work for an organization that had a financial services aspect and you also had a supermarket element. If you go to a store and you buy a certain item and it's a high ticket item, it would not be right for that organization then to send you some financial service information about credit cards or about other additional services that they offer, because it is nowhere near linked to the original purposes that you entered into processing of that data. So it has to be, there has to be a reason why I would be interested in knowing about this particular service. It cannot just be the legitimate interests are not your legitimate interests, it is the legitimate interests of the individual. So if I go to a law firm and ask for certain legal services, it is right and proper that they offer me additional complementary services, but they can't simply pass my details on to an accountant who might also be one of their partners. So again, it's very careful when we start talking about marketing here, where people ask, is it okay, once someone buys something from us, do I have to ask for their consent to tell them about other services that we offer? No, you don't have to ask for their consent, because you are doing so, you know, it is in their legitimate interest for you to tell them about additional services that you offer. And I labour on these 2 points around consent and legitimate interest because these are the 2 areas which have received the biggest amount of misinformation that's out on the web that I've seen. And I hope just by going through that, that just helps you a little bit, certainly with being able to promote your business. So the final part of this presentation is, of course, the do's and don'ts, the thumbs up and the thumbs down. So this is where I'm going to try and help you with a little bit of advice and guidance as I can. What I would say to you is this: brace yourselves, because GDPR is of course coming. This is happening. It's on the 25th of May, of course. That's when the date is. It's a Friday for those of you who are of keen interest. Are we likely to see a flurry of activity around that date? Absolutely. We're seeing that certainly within my business. Will we see a flurry of activity by the ICO shortly after? Who knows? All I will say to you is this, is that whilst the 25th of May is very important, and I'll come on to it again towards the end, we need to remember that this is something that impacts us all, and you need to embrace it and start to think about it within your own organisations. And if you haven't given somebody the responsibility to be your data protection lead at this point in time, then you need to think about doing that now. Because some of the things that you should be doing, of course, is you need to decide if you need a data protection officer. There are only 3 bases upon which you would require a data protection officer. One of those is, and it's nothing to do with the size of your organization, but the first reason that you would want to know if you would need to have a data protection officer is if you work for a public authority. The second is that you are processing large amounts of data, so that if you are a hosting organization, that's possibly you, or that you are processing large amounts of sensitive and personal information. And sensitive can be, of course, children, it can be medical records, and trade union and other sensitive kind of information. The key question you have to ask is, well, first of all, decide if you need a DPO, and some of you probably will, and but more importantly, you need somebody to lead your compliance program. You need somebody to make sure that you tick the right boxes. This isn't a tick box exercise, but that you have considered all the things that you need to do. And of course, you need to speak to your clients about the GDPR, because unfortunately, we all have a role to play in this. And one of the things you cannot simply think about this is that it's not your monkey and it is not your circus, i.e. it's not your problem. It is, it absolutely is. It is your, the obligation is on you to understand your own data usage and your that of your clients as well, and make sure that you can demonstrate to them that you're thinking about data protection in its broadest sense under GDPR. What I would suggest and urge you to do, and this is where again we almost come full circle to the beginning, where Elizabeth Denham was talking about building trust with your clients. You'll work with your clients. You know, understand, are you the processor, controller, or are you both? You may be, you can have joint controller basis. So understand who it is that's actually, you know, what role you have to play and what the obligations are. Speak to your clients now. You know, how will you assist them when you're responding to any data subject exercising their rights? So their right to access. So if somebody does a subject access request, where does that request come from? Where is it going to? What if that person asks for the return or erasure of their data? And of course, how do you respond to data breaches? Going back to the headlines that I mentioned right at the outset, which is that any breach that you will become aware of needs to be notified to the ICO, or may be notified to the ICO within 72 hours, or the data subjects themselves. There are caveats around that reporting requirement, but the question has to be asked: how would you respond? Do you have a process right now? And of course, you're going to start to see this in more detail now and more regular, which is this right of audit, where organizations will be saying, we need to audit you, and we're going to start to send you countless questionnaires. Are you ISO 27001 certified? Are you GDPR compliant? How can you evidence that? Because we are going to hold you accountable if you can't. So they're going to want to understand your position. So understand their needs and what that position is, so that you can better prepare for it. And again, I cannot emphasize this enough: build that trust with the organizations that you are working with. Because when all said and done, GDPR really is closer than you think. You know, 25th of May really isn't that far away. If we take away the weekends, presumably you don't work weekends, or you don't want to work weekends, it is in actual fact just 91 days away. Now, whilst that may scare you, the reason why I put the lady holding the diet there in front of you is that the way that I would urge any organisation to approach GDPR is to approach it as a lifestyle change. No one really enjoys dieting, I don't think. I know I certainly don't. But we know it's good for us. We are living in a world that is suffering from information obesity. So it's a good time to get healthy and to get better at our data protection and our information management, if you like. So whilst we are focusing absolutely on these 91 days, and I understand that, and you know, I have a little calendar that I'm marking off the days, but what we should be seeing this is a lifestyle change. We should be thinking about the way that we consume data, so that we can actually start to use it better, and we become fitter and healthier, and ultimately all live a far happier life and safe in the knowledge that our data is being protected. So ladies and gentlemen, I hope that has been of interest. I will now attempt to hand back to Janet, I think. Would that be correct?
That is correct, Gary. Okay.
Fantastic. Thank you very much for your time.
Okay, so while Gary is handing back to me, and the purpose of going back to me is that I am going to address some of the questions that you have been sending through. So Gary, so first question is, it's as an MSP, if there is a data breach, who will the ICO come after? Will it be the controller or the processor?
It's a very good question. I asked that very same question of the ICO a couple of years ago, and the ICO's response was the reason that they've made the obligations on the data processor almost the same as the data controller is that they will decide at the time of breach who is most culpable. So they will investigate where the breach occurred and how it occurred, and then they will take appropriate action against that that company, that organization. Okay. So it will depend.
Okay. So we have a comment from Jack who says that unless you talk about the fines to clients, then they're not likely to implement GDPR. And he also says that tax records for HMRC investigations require 20 years. So something to bear in mind. Yeah. Okay.
Yeah, absolutely. And what I would simply say is that every organisation I come and speak to, they come to me with a different requirement and their different timeline for different reasons. When I work with law firms, they'll say, well, we've got a asbestos case here. This person is 25. We may need to keep these records for 50 years past the date of this person passing away. So my response to that is I smile and I just simply say, all it simply says within the GDPR is that you can only hold data for as long as is necessary. It is up to you as a business, therefore, to determine what is necessary. So if 20 years, it's 20 years. If it's 100 years, it's 100 years. But that ultimately is what it's about. GDPR is not there putting hard and fast rules in place in some respects. It is simply offering guidelines around what it expects to see, what it feels is reasonable.
Okay. Well, this is an interesting question. It says, where we enter into an MSP contract with our clients, then a single member of that organization will sign the contract. Staff within that organization have not signed the contract, and yet we will likely email those individuals. So is that covered under performance of a contract or legitimate interest or consent?
If I understand the question correctly, it would be for the performance of a contract, because the whole point, you are emailing people within that organisation based upon the contract that has been put in place. So and again, it is a good question. This is where I urge everybody to review the contracts that are in place and make sure that it states quite clearly that what you are going to do. So we know of companies who are pension organisations who will enter into an agreement with the principal legal entity. But of course, once they've entered into that, or health, Bupa being, for instance, maybe that they will then email me as an individual and say, Gary, you've been entered into a Bupa healthcare, and here's all our services, and this is what is now on offer. I would just simply be saying to the organisation, you just need to make sure that your employees are aware of that, and that's what may happen. But you are entering into a contract with the organisation, not 200 or 300 individuals within that organisation.
Okay. And next question, Gary. So, would you say a recruitment company needs a DPO? And the second part of that question is, and what would you say to people who are saying that IT people should not be the DPO? So, two parts to that.
Okay. I would say, would a recruitment business potentially, depending upon the size of that organisation and the amount of data that they are processing, quite possibly. So apologies if that sounds like a legal answer, but again, this is where GDPR is meant to be there for interpretation by you as a business, individual business. So if you are a small recruitment agency of 5 or 6 staff, and you've got a couple of 100 people on your books, then unlikely. I would say you wouldn't need a data protection officer. You can outsource it, so you can have several recruitment agencies might want to use a single outsourced data protection officer. But if you are a multinational recruitment agency, then the answer to that would be probably yes. So I hope that's given you enough to answer that. In terms of the second part of the question, the reason that you shouldn't have somebody in IT as being the DPO is that the role of the data protection officer has to be, there can't be a conflict of interest. So typically, the position of the data protection officer is of somebody who has both legal or data protection skills and experience, but is also sufficiently away from the processing and the day-to-day processing of data. So unfortunately, as the head of IT, if there was a data breach on your watch because you hadn't, I don't know, implemented proper patch management, or you've not spent enough time or effort or money on resources, then there's a conflict of interest, because there's a chance that you might want to try and hide the fact that that has occurred. So that's the reason why the designation of the DPO is so important. So it's not just that the head of IT can't be the DPO. I would say the head of operations can't, the head of finance can't, the head of marketing can't. So your CIO, your COO, your FDs, all those people cannot be a data protection officer. Usually it would be somebody who is completely independent. So it could be an information security manager who sits across all those functions, or the head of risk, or the head of compliance, or the head of audit. Someone who has overarching control and management of your governance, your data governance.
So I'm going to jump in with a question on that, Gary, because I know that some MSPs would be looking at offering data protection services as, as a service. And if they're doing that, then should they say, well, I can offer data protection, DPO, as a service, but not to people who I'm also managing their IT infrastructure?
Okay, yes, in the strictest sense of the words that you just described there, as long as they are, so I'll expand on what you just said, as long as they are employing people who have data protection skills and experience, so an understanding of the regulation, because although we're talking about GDPR here, the DPO would also get into conversations about other aspects of data protection law. So there's another regulation called the Privacy and Electronic Communication Regulation, PECA, which is going to become more widely known as the e-privacy directive, of course the data protection bill. So there is quite a lot of compliance aspects to this, as well as information security risk management, which I'm sure lots of the MSPs out there do have. As long as they are not the provider of those technical services already, yes, they could do that, and they could become all things to all men. Open, honest sort of responses. That's what agencies do in terms of we partner with MSPs already who don't have those skills, and they simply partner with those and say, we sell agency capabilities into our clients so the client gets the best of both worlds. They can serve them as an independent MSP, but still providing them with a data protection officer type skills and experience. So there are, partnership opportunities out there, and not just with us. I'm, open disclosure, there are other people doing it, although not as good as us, of course. But there are people out there doing it. But yes, the short answer is yes, you could do, but you'd have to be very careful of how you would frame it.
Okay. Okay, so next question from Mike, who says that as an MSP, if we have AV, antivirus in place, firewall, encryption, etc., and then there is a hacking attempt, and I presume a successful hacking attempt, who will be responsible, even though we've put all these protections in place? I'm assuming he means we put those in place for the customer. There's a breach. Who is responsible? Okay.
Again, apologies for sounding like a lawyer, and as I mentioned, I'm not a lawyer. But again, the answer is it depends. But I will say that the whole point of GDPR is not to come and hit people with a stick. What they would do is they would simply, if there was a breach, and if it was a reportable breach, and the ICO were to come along and investigate you, what they would look to do is they would look at essentially what what's happened, what has happened in the organisation. The conditions for the actual fines themselves. It really does depend upon the nature and the gravity of the infringement. What's actually happened. What actually happened when it occurred. What's the level of damage that's likely to be suffered. They're going to want to look at the intentional or neglectful character of the infringement. So if you, as an MSP, or even as an end user, can say, look, with all due respect, we had the breach, but we had this measure in place. We had the firewalls, they were patch managed. We went to this service provider, we audited them, we've got a contract in place, we trained our staff, we had antivirus, we had anti-malware on endpoint solutions, we had password protection, we had passwords that changed every 30 days. We did all of these things, and unfortunately, we had a rogue employee who did X, Y, and Z. The ICO is highly unlikely to levy any kind of fine against you, any kind of enforcement, not fine, but enforcement against you. Because again, it's the controls that have been put in place, the degree of the responsibility of the controller or processor, what where was that responsibility? So if you, as an MSP, were putting those controls in place and you said, we can demonstrate, we patched those machines and we updated the malware every single day, but that director didn't follow our rules and didn't follow our instructions, then obviously the MSPs are unlikely to get any kind of enforcement, and it would be more towards the client. I hope that's an answer. I apologise if I sound like a lawyer, and that's no offence to any lawyers who might be listening.
Okay. So Gary, this one comes up quite frequently. If you receive a business card from a person at an event, can you take that as being consent, or do you then have to go and ask them for consent as well?
Okay. No, you wouldn't have to ask them for their consent. I always say that it's good professional manners that if you email somebody who's given you a business card, you would remind them where you met, because they may have given their business card out to lots of people. So you would, I would say, as a matter of courtesy, you would just simply say, hi, it's Gary. We met at this the event the other day, and you asked me to contact you about some of our services. You said that you were interested in it, and I think most of us would. You're not asking for consent. The fact that they have given you their business card is evidence or a demonstration that they are wanting to enter into some form of sales negotiation. And again, that's a very simple, I wouldn't even say process. That's just the way that it should work. And it is a question that comes up quite regularly. And what I would say is that to anybody who asks that type of question is, we have a lot to do around GDPR, and if we're worried just about the business cards, that is really sweating the small stuff, and we need to move beyond that. It's a little bit like worrying about the ice cubes on the deck when the iceberg is dead ahead. So we need to focus on the bigger picture first, and then start to deal with some of those smaller aspects later.
Okay. So this is a question around legitimate interest, and the question is, we run regular security briefings, and people attend who are not our current customers. When we follow up with emails to them, is that considered legitimate? Is that considered legitimate interest?
If they've signed up to your event, and you are wanting to tell them about other events that they have previously attended, yeah, that's not a problem at all. It's a legitimate interest. I would always urge, and again, this comes more into PECA, you would have an unsubscribe button, or just have an option to, if you do not wish for us to inform you about future events, please email with the following in the subject line, so that they have a right to remove themselves from any future events, because they may have come along to your events and they may not have enjoyed it, and I'm very doubtful that would ever occur to any of these events. But if that was to happen, you want to make sure that you don't contact people unduly, but it would absolutely be legitimate interest.
Okay. And the final question is around informing the ICO, and under what circumstances would you not have to inform the ICO about a breach?
Okay, so informing the ICO, it's in terms of why you would need to inform them. First of all, if the breach is likely to have an impact upon the data subject's rights and freedoms, that's when you need to consider whether you need to inform the ICO or not. Why you wouldn't need to inform the ICO, and it uses the word may, you may not need to inform the ICO or the data subject, is if appropriate technical or operational controls have been put in place, e.g. encryption or some other form of anonymization. Now, I labour on those words very carefully, because what I don't want people to go away with is this idea that encryption is mandatory, because it's not. Encryption is just one form of risk mitigation, and it talks about encryption within the regulation. I think the word appears 4 times, and that's all it appears. So, you know, if you are if the data is encrypted, then you're not required to inform the ICO. You're not required to. Whether you should or not is a different question. And as I said, if it's likely to have an impact upon individuals' rights and freedoms, I think that's the key question. There is, what is the impact upon the individual?
Okay. So, actually, another question is coming in. Will cyber insurance be used as a get-out clause for many companies rather than do the hard work involved?
I sincerely hope not. I mean, it's a really interesting question. Cyber insurance will only go so far. I know a few organisations which are, or a few policies out there that do pay for any fines on indemnities. So possibly, I think, but it will be some of those big ticket organisations. I don't think it'll be something that the smaller businesses will be able to rely upon. And I think one area I would suggest is, not having read every single cyber insurance product that's out there, I've certainly read a fair few. If you can't demonstrate that you put the basics in place, then your insurance policy will be null and void anyway. A little bit like saying, if I have a car crash and I don't have it MOT, can I still claim on it? You've got to keep your car in a state of repair, and you've got to be able to evidence you've done that. So you'll come under a certain amount of scrutiny from your insurer anyway if you had a data breach.
Okay. Gary, that's all the questions, and it's perfect timing because we're at the top of the hour. People have asked, are we recording this? We are recording it, and we will, oh wait, just one final question. So if clients are refusing to do anything with GDPR, should we disassociate?
My very honest Yorkshire answer to that is yes. I like to work with people who I can trust, and as I showed you on my slides, and which is enshrined within GDPR, who could argue against those 6 principles? If you're telling me you're not going to act lawfully, fairly and transparently with data, and you're not willing to take precautions to hold it with integrity and confidentiality, do you really want to work with that type of client? That's the question for yourselves. But I personally have walked away from clients who don't believe in treating data with respect.
Okay. All right.
Thank you. Good question, though. Good question.
Okay. Well, Lucas, Gary, I think that's that's been really useful. As I say, we are recording it. We will send out a copy of the recording to everybody who's on the line. And if anybody has any questions, don't hesitate to come back to ourselves. We'll also be sharing Gary's details with you if you want to talk to him directly. Okay, so thank you all very much, and I hope you had benefit from it. And thank you, Gary.
Thank you very much. Thank you.
Thank you very much.
Bye-bye.
Bye.